Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. Hi, I'm going to read this statute and then at the end I'll discuss it. If you have questions, reach out to me directly. 25.316, Temporary Orders Definition. In a proceeding for a dissolution of marriage, legal separation, or annulment, or for maintenance or support following a dissolution of marriage by a court that lacked personal jurisdiction over an absent spouse, either party may move for temporary orders seeking any of the following. 1. An order for equal possession of the liquid assets of the marital property. 2. Temporary spousal maintenance. 3. Temporary legal decision-making and parenting time of a child common to the parties. 4. Temporary support of a child, natural or adopted, common to the parties entitled to support. 5. Exclusive use and possession of the family home or the home of the moving party. 6. Exclusive use and possession of other property of the parties. 7. An interim award of attorney's fees and costs. 8. Other relief deemed necessary pending a resolution of the issues. B. A party who seeks an order for equal possession of liquid assets shall file a motion that is accompanied by an affidavit setting forth the factual basis for the motion, the amounts requested, and if appropriate, the liquid assets of the parties. If granted, the court shall provide an order for equal possession of the liquid assets of the marital property that existed as of the date of the petition for dissolution, legal separation, or annulment was served, unless the court finds there is good cause not to divide those assets. The court's division of liquid assets by a financial institution does not invalidate applicable law or any provision of the account agreement that assesses penalties against the account holder for premature or unscheduled withdrawals of the money. An order for equal possession of the liquid assets of marital property does not prejudice any final division of the marital community. This subsection does not eliminate the application of the preliminary injunction. C. A court may issue a temporary order without notice regarding the other party only if it finds the basis of the moving affidavit or other evidence that irreparable injury will result to the moving party or a minor child of the parties if an order is not issued until the time of responding has elapsed. A bond is not required unless the court deems it appropriate. D. A temporary order. 1. Does not prejudice the rights of the parties or of any child that are to be adjudicated at subsequent hearings in the proceeding. 2. May be revoked or modified before the final decree. 3. That provided for equal possession of the liquid assets of the marital community does not prejudice either party's claim for temporary maintenance, child support, or attorney's fees. 4. Terminates when the final decree is entered or when the petition for dissolution, legal separation, or annulment is dismissed. E. For the purposes of this section, liquid assets include cash, traveler's checks, non-retirement funds in financial institutions, lottery winnings, cryptocurrency, coins, and precious metals. So this statute, as you can tell, has been updated throughout the years because it includes cryptocurrency, which is exciting because Arizona is really trying to keep up with things that are going on, and we frequently update our statutes, sometimes on an annual basis, and sometimes they don't, but this one really has been updated, and I think that that's a benefit to the parties. In a dissolution case, the biggest issue that I see is one party who might have had the online access to the bank accounts, things like that, locks the other party out. Turns off their credit cards, takes their credit cards away, shreds their debit card, removes cash from a safe. There are all of these shenanigans that sometimes take place at the beginning of a case. And filing for temporary orders can alleviate some of those issues. For instance, if someone took all of the funds and put them into a new bank account that the other party doesn't have access to, thankfully there's still going to be a paper trail most likely for those, and we'll be able to claw those funds back and get them divided equally pursuant to the statute, unless there's an equitable basis not to do that, so that they are able to both live, pay their expenses, pay their attorney's fees, and move forward with the dissolution process. If you do have questions, feel free to reach out to us at Arizona Family Law Attorneys.